Please be seated.
Come on, everybody. We have a number of things on the docket this morning. We want to kind of take care of them as quickly as we can.
Mark got tentatively ready, but I didn't have contact.
Cortez Dryden. Jonathan Carr.
Actually, his appearance was waived from the defendant's
Stephen Chance pled on May 6th. Matthew Chilton.
Also tentatively ready, please.
Devin Cornelius. Sergio Galvin.
We can mark that tentatively ready, please.
Angel Gowan.
She is present. Please mark that ready.
Randy Hendricks.
I'll be handling that, Judge. Mark it ready.
Matthew Howell.
Stand in line at the front door, Your Honor.
Abdi Rashid Ibrahim. Matthew Inman.
Judge, that was a matter we've asked to be placed on the docket dealing with his restitution or lack thereof. And I believe the clerk was maybe had mailed him a
I did, and he did receive it because someone signed the certified. Gerald James.
I believe Ms. Hennig and Ms. Diener had discussed continuing that case to June 17th. If that's acceptable with the court. I know there's a general sessions case that's involved in this as well. That's set
I wouldn't
earlier.
have given him June 17th, but I'll look at my email and see.
Okay.
but I do agree with
The week after, I think. The week after would be acceptable.
Yeah, I'm sure I gave him a date.
Thank you.
Kevin Kelly.
I represent Mr. Kelly. He's present, Judge. That's my motion.
Miguel Martinez.
He's here, Your Honor. Mark it ready.
Glenn McCrae. He's here from TDOC.
Mark that ready for Ms. Smith, please.
Denver McMath.
Judge, I believe that matter is actually ready to pick a hearing date.
Alan Moses. That's be continued to July 6th by agreement.
And the reason that is Mr. Moses is undergoing outpatient drug treatment.
All right. Thank you.
Bobby Raines.
He's present, Judge. We can mark that ready.
Laverne Russell.
All right, Mr. Russell, President, and that was the general assessment of the bill that's going to be answered by Mr. Johnston with the DA's office. That'll be for announcement whenever he arrives.
Jackson Saunders.
He's here, Judge. I'll handle that. Mark it ready.
Brian Sword.
Tentatively ready, please, Judge. Thank you.
Aubrey Sowell.
Judge, that's a motion to suspend that is in another court as well today. Mr. McGee will be back once that's.
Michael Terrell.
I represent Mr. Terrell, Your Honor. He's in federal custody. We can
Your
mark
Honor,
that ready.
he is in federal custody. That matter remains on the court's trial docket on June 6th. We were going to discuss with the court, Mr. Calrissian and I, removing that from the trial docket because we will not be able to get custody of him and his trial is still pending in federal. All right, we can take that up after the break.
Najee Turpin.
Mark that tentatively ready, please.
Brandon Vandenberg.
Yeah, we're here, I have a waiver of Mr. Vandenberg's appearance that I need to print out this evening. I'll send it.
Okay. What number are you ready?
Just forward it to me. Forward it to my email. Alfred Whitehead. Frederick Whitehead.
Is he in TDOC?
I don't think that he is. We wouldn't have brought him in anyway.
Right.
Frederick Whitehead.
He's here, Your Honor. Mark that ready.
Joe Urito. His presence was waived. We marked that ready.
And actually, Judge, the only reason it's on the docket is that this was a joint and several liability as far as restitution. Mr. Urito has paid his half, and that's why we're trying to get Mr. Inman in to see if he's going to pay.
That's the call of the docket.
It's okay. We're going to take a short recess, and then I'll come back and start hearing that. All right?
All rise. Board will be in a brief recess.
Yeah, I mean, subject to. Yeah, so. Anyway, I said, y'all, that's pretty much going to be.
Yes, sir. Mr. Benjamin? Okay. You'll have to see Mr. Benjamin.
Way to get him 140 years.
I don't want to next year. Talk to you.
It's a way to get him 140 years.
But yeah,
This is where he was working when this election was going. I think that they have, they tried to get his moniker, his station, his appointment. So if you're okay with that. Or his work right here. Yeah, I didn't give it a legal order, I just want to keep those, you know. Yeah, I had it. And I'll give you a copy of that.
Kylie, come here for a second. Now listen, I'm looking at your files on the website. No, can't figure out if you're,
Basically, the effective date is 8/85.
Everyone to remain seated, please come back to order, court back in session.
Okay, we have motions to be heard on the Vanderibilt matter.
Judge, there may be one or two brief announcements on the regular docket.
Okay.
That's correct, Your Honor. On page 9 of Your Honor's docket, Mr. Laverne Alexander Russell,
Okay.
the state is going to retire that matter for 90 days.
Where is it?
He's right here, Judge. I previously explained to him his rights to speak trial, but he's going to use this resolution.
All right. Mr. Russell, I think you just heard the attorney state that the state has chosen to retire this matter for 90 days. Do you understand what that means? All right, this matter will be retired.
Thank you, Judge.
Anyone else?
Your Honor, on Mr. Howell's case, I had filed, as you remember, a motion to recuse that was
Right.
heard 4 weeks ago, and Your Honor said you were denying it, but, and that you were going to file a written order.
Right.
But I haven't gotten any written order yet.
Well, I haven't signed it yet. I will have that in a matter of a couple of days.
Well, I guess the point is just, the law is that cases aren't supposed to proceed until that's
I
been
understand.
accomplished. And so I was wanting to see if we should reset this for either 2 or 3 weeks out.
We'll have to reset it, yes.
All right.
you want to set it June 3rd,
Sure.
for Friday, is that?
Yes, that's
Okay.
fine. Thank you.
Anyone else? Okay, are we ready on Vanderibilt?
Yes, Your Honor, I believe so.
So I'll let you know which one.
Okay.
Which one do y'all want to?
Well, as our court and counsel, since Mr. Tilley is here, we can address the Rule 15 deposition.
Right. And with regard to Ms. Tilley, I checked with, well, this court reporter right here. And she was the one who took our, she took down the hearing and she said that the parties actually agreed to Ms. Tilley coming in and having her deposition taken. And so, we can proceed with that. If you want to do it now, we can do it now, or we can do it a little bit later.
Well, if I could go ahead and address that, because I might anticipate that counsel is going to say that the verbal agreement that was, we thought, reached, that would have resulted in the Rule 15 written agreement being filed, because the rule does say that upon written agreement of the parties, that the deposition can be taken without leave of court. I'm not quoting it exactly, but I believe that that is the requirement. And following a number of discussions, it became obvious that counsel was not willing to sign an agreed order for the deposition and was insisting upon the state filing a motion for same, which we have done, and which we believe set out in the motion that Ms. Tilley is a material witness in this matter, that it would create a substantial hardship for her to be required to end the trial, and that this is a matter where obviously her testimony is known to defense counsel by 2 trials now that she has testified in. And I would submit that, without being overly cynical, that the defendant's response under paragraph number 7 is essentially what really this is all about. I quote, Mr. Vandenberg would not oppose a continuance of the trial date of this cause to a date that does not conflict with Ms. Tilley's plans. Certainly, I am sure he would enjoy having more time at liberty while this case languishes as it is not paid any call to the court, has done for some almost 3 years now. But given that, the state is unwilling to ask for a continuance of this matter and instead would insist upon the trial proceeding as per your Honor's very explicit order, that there will be no continuances of this matter. And to that end, the state would strike its request. We will proceed with other witnesses and would ask that Ms. Tilley be excused from her subpoena.
Mr. Reagan?
I don't know, respond to that, Judge. It's perfectly heard that this morning. Obviously, if the state is going to proceed with other witnesses and release Ms. Tilley from her deposition subpoena, we have no objection to that.
I just want to make clear, hopefully, that there would be no defense subpoena issuing for Ms. Tilley. In other words, that the court would release her from any further obligation for the trial of this matter the week of June 13th.
And, you know, please, we cannot agree to that. We may need to subpoena Ms. Tilley herself. Yeah, the state's not with that.
Well, she wouldn't be available on that day, on the week of the trial, as you know, unless you just have her prior testimony presented to the jury. So, what do you?
Well, Judge, I guess at this point in time, I don't think I have any option except to ask the court to issue a subpoena from Ms. Tilley for the trial. We may be able to release her from that later. But out of an abundance of caution, I would ask for a subpoena issued for trial.
She is available for a deposition today, as we had discussed weeks ago.
So, I mean, she's not available during the week of the trial. She is available today. And I am here. I can hear her today. I don't believe her testimony was that long, as I recall. So we can proceed today.
Well, Judge, we're not prepared to take her deposition today. The state had filed a motion for deposition. We filed a response, and we thought we're probably here today to argue that motion as to whether or not the deposition would be scheduled.
I certainly disagree with counsel's recollection of that. Again, per the discussion that was had with Your Honor, that she would have been available and was on April 29th. It was referred to today, knowing that she would be available.
All right. So, Ms. Reagan?
Well, Judge, my notes from the status conference, my notes say that Mr. Bowen said the state should file a motion for deposition.
Well, that was the last time, but the prior time, the parties agreed to have her deposition taken. Last time we were here, that's when the parties disagreed.
But quite frankly, I don't recall agreeing. If that's what's in the transcript, then I guess the transcript of the rule.
I could have the court reporter pull it up.
That'd be fine, Judge. But again, we're not prepared to take her deposition today. Mr. Vandenberg has the right to be present at that. He's waived his presence for this motions hearing today. We thought it was going to be a motions hearing, not deposition.
I don't know when it could be done unless we come back next week.
We could We could do it next week.
Judge, I'm not being able to speak for Mr. Reagan, but a suggestion that I would have, if we get a subpoena issued today, and if after we review and consult with other members of the defense team and Mr. Vandenberg, we may in fact release Ms. Tilley from that deposition. I can't say that right now today, given their redaction or striking that particular motion. What I can say is, if we are not in a position to release her from that subpoena, and this court instructs us to take her deposition, we would be inclined to take a video deposition of Ms. Tilley, and we would do that within the next 2 weeks. We absolutely would do that. But I would think that we issue the subpoena, we'll notify this honorable court by Monday morning if we intend to not release her from that subpoena, then we'll take her deposition prior to that video deposition. That logistically, I think that would work. We'll take it next week or the next week, convenient for Ms. Tilley, should the court instruct us to take that video deposition of Ms. Tilley.
John?
Would that be, Your Honor, with the anticipation the council would be filing a motion for a Rule 15 deposition?
I don't know.
Well, are they agreeing to it? I mean, we'll file a motion and they can object to it, or we don't care to file a motion. We'll file a motion, Judge, if that's what they're asking. But they.
I don't mean to be getting bogged down with this, but agreeing to something in writing seems to be a difficult matter, and the state certainly is not willing to pay expenses or anything Mr. Vandenberg has waived his appearance today, which was the date that we understood was the date for her deposition. So that's for the state's position. Certainly, no, if they want to, if the defense wants to take her deposition, Ms. Tilley is available and we can work that in, that's fine. We will sign off on that written agreement with the understanding that it would be either Mr. Vandenberg pays his own way here or waives his appearance. I think that's only fair.
Okay. Well, Mr. Reagan?
Well, Judge, the question I would have is that if we do get this deposition arranged, and is the state saying that they do not object, that she's not unavailable? Are they saying that they're agreeing she's unavailable for trial?
She's unavailable for the trial, yes.
Yes.
But she's available some other, I'm assuming, I don't know. Ms. Tilley, are you available like next week or week after? Okay.
If we can get with Ms. Tilley and with the state, then we can let you know by Monday.
Okay. All right.
But I would. I don't want to speak for Mr. Reagan again, but I would just ask the court to issue a subpoena. We'll let the court know by Monday if we withdraw. My understanding is the state has withdrawn their motion to take the deposition of Ms. Tilley. Given that fact, then the burden would be on us to get Mr. Vandenberg here and pay those expenses if they've withdrawn our motion, because it will.
Or waive his appearance.
Or waive his appearance, one or the other. But since they've withdrawn their motion, the burden is not on them to secure those financial resources to get Mr. Vandenberg here.
Correct.
So that's, just make it clear that that is on us to get Mr. Vandenberg here during that video deposition, Ms. Tilley.
Right. Okay. Let's move on.
Well, the next matter, General Norman will address was dealing with notice experts or lack thereof dealing with Mr. Kemp Bonnie. Need to spell him.
All right.
Your Honor, the state filed a motion to exclude expert witnesses as notice has not been provided to the state pursuant to Your Honor's order. Your Honor set an initial deadline in September. Your Honor extended that deadline to October. And then in October, when the trial was continued, Your Honor set a final deadline for notice of expert witnesses. Your Honor was very specific and stated that that included any expert reports, and that was set for December 1st of 2015. Defense counsel has provided what is styled as a notice of expert witness. However, it only lists the name of two different experts. Since the experts are very different in that one is governed by Rule 16, the other is governed we're asking to address them separately. So specifically related to the digital forensics, they have filed the name of Kemp Banning, Jim Kemp Banning, I believe it's Kempbanee. He said that he is an expert in digital forensics. That is the extent of the information that's been provided to the state. We have not been provided with any report, any iota of a semblance of what he might be testifying to, as digital forensics is a large subject matter. We don't know if we're talking about phones, computers, which ones, and so the state's just requesting that the court exclude that witness based on the failure of the defense to file notice of expert witness.
I think in the filing I read this morning, they were talking more about him possibly, him or her, whatever the case may be, being a rebuttal witness, an expert rebuttal witness, and therefore they did not have to provide any reports. I will let them speak for themselves.
Judge, in regards to Logic Force, Jim Kemp, any of the associates that work with Logic Force, I would point out a couple of things that the court has, this isn't on, Judge,
No, it's not on.
has pointed out as it relates to the rebuttal. Clearly, as a rebuttal witness, the state is not entitled to that expert, that notice of expert. We argued in our motion and we pointed out to the court, should the court be inclined not to consider Logic Force in the field of digital forensics as a rebuttal witness, then we gave notice out of an abundance of caution. Judge, since 2014, the state has been on notice of experts by Mr. Vandenberg of digital forensics experts reports. They've got their own expert. They've got Detective Gish, which has been qualified as an expert. If Detective Gish were to respond or provide testimony on direct or cross-examination, we don't know that we would need to call our own expert, as pointed out in our rebuttal argument. But should those facts be not the facts that the defense would see them, then we would call our expert as a rebuttal witness, which provided we don't have to provide any notice at all. But out of an abundance of caution, we provided that notice of Jim Kempany with Logic Force and any associates that may work with him as it relates to that particular motion. So there's three arguments. Number one is a rebuttal witness. Don't know that we need him, but we might. No, we surely need his expertise in sorting through this digital forensic evidence that the state has previously introduced and I believe intends to introduce at this point in trial. Another point is if the court were to say, well, this isn't a rebuttal witness, we would respectfully submit that it is a rebuttal witness, that the state is not prejudiced whatsoever by the digital forensics expert called by Mr. Vandenberg. They've been on notice since 2014. They had an expert report prepared by Mr. Vandenberg, then expert out of California, here in Nashville, the Jacobs Group, I believe, the judge. So they've been on notice, and in fact, they have their own expert, Detective Gish, that will provide testimony. The rules regarding the disclosure of expert testimony does not suggest to disclose your expert for purposes of identity of an expert, but to put the state on notice of the category of an expert. It has nothing to do with the presenter. We're just asking this court to let us present through Logic Force or Jim Kempany with Logic Force this digital forensic expert testimony. They've been on notice. They're not prejudiced in any regard whatsoever as to our notice. So we would ask the court, and it's a drastic remedy, the courts have pointed out, to exclude expert testimony when they've got their own expert. They've had their expert ever since the inception of this case. They've been on notice of our expert, the Jacob Group. We filed two motions, as a matter of fact, adopting any and all previously filed motions, notices, etc., as it relates to Mr. Vandenberg's case. We would respectfully ask this court to allow our experts
to provide testimony.
Judge, the state is somewhat befuddled by defense counsel's argument that they only intend to call their expert in rebuttal proof. Rebuttal proof for the defense, as they are referring to it, would be surrebuttal. The defense case in chief, they cannot refer to that as rebuttal testimony just because it comes after the state's case in chief. That is an incorrect statement. That is not how the law perceives it. Specifically, in light of Rule 16, very specifically, it refers to any evidence that the defendant intends to introduce at trial. And there is case law that references whether or not that applies to a pretrial competency hearing. And it specifically states that the term at trial necessarily limits the rule's application to evidence introduced during the portion of the proceeding in which guilt is determined. That is the defense proof. In and of itself, stating rebuttal proof as a reason to not comply with Your Honor's order that was very specific, that they had to not only provide the name and the report, but to come up with some type of procedural rule of which they have presented absolutely no case law, anything that says anything about rebuttal proof, and that creating some exception. They have further gone on to tell this court that the state is in receipt of a report since 2014. Now, I'm not sure what their explanation could be for how this new expert is relying on someone else's report, but that doesn't really matter because the state has never received a report from the defense. We received the name Julie Jacobs, who was a completely different person, and we received her resume after having to make a request of the court to instruct them to provide it to us. There was an extraction of Mr. Vandenberg's cell phone that was provided to Ms. Jacobs, along with a copy of the hard drive of his laptop computer. And after that, nothing else was ever said about it. We've never received a report. I cannot stand here and argue all of the ways in which the state is prejudiced because there is nothing at this time that they're asserting so that we can make that argument. I can conceive of many ways in which we could be prejudiced. We have no idea what, if anything, was done in digital forensic analysis of the extraction or the hard drive. Depending on what was done, absolutely. Detective Gish is here. I could call him to the stand if we have this information, and he could explain to Your Honor how that would prejudice the state and how having notice so that he could follow up and be able to respond to that, we would be able to do that. But again, the defense is trying to withhold information from the state that Your Honor has ruled that they must provide. They're trying to do it citing some type of a tactical advantage, which, I mean, it's just ludicrous in this situation. They've further gone on to say that they are only required to provide us with the category of the expert's testimony. Again, that is not true. It is well-settled case law in Tennessee that they are required to provide the report. And part of the reasoning behind that is once the report is filed and we know what the expert witness is going to say, even if we have our own witness, there are still additional considerations. It might be that whatever their expert is saying is not recognized in that field. And we need to file a motion contesting whether or not they should be allowed to testify at all. All of this would affect the pace of the trial, which we have a trial upcoming that has been reset several times at the defendant's request. Your Honor has taken steps to have an out-of-county veneer at the defendant's request. All of that is scheduled, and we now have a situation where we have a sequestered jury Your Honor has full authority to set any deadlines related to a trial, which again, Your Honor has done. And the defendants comes into court today saying they are not going to comply with your order. No matter how many times it is said to them, they are not going to comply with that order. But especially because we have a sequestered jury, Your Honor has full leeway to set these deadlines and to enforce the deadlines by excluding their witnesses so as to not delay the trial.
For a response to the Judge, just briefly. God, please.
Rebuttal. What's interesting is that the state uses words like "this is the defense's case," "this is their," and then goes on to suggest that the state has no inclination of what this expert would testify to or wouldn't testify to. If Detective Gish, for example, were to take a stand and say this particular software only can produce 3 reports, and I've got those 3 reports, and in fact the software produces 9 reports, and those reports can be, that's rebuttal. That's expert rebuttal that someone knows if that testimony were to be elicited at that point in time. It's clearly rebuttal. If one individual says one thing exists and it in fact doesn't exist, that's rebuttal. Again, Your Honor, please, what's interesting is we and I can't go down that road. We are receiving notices of prior experts that the state has filed back in 2014, in which we haven't got notice of today, in which they're relying on, that they're going to call a trial in Mr. Vandenberg's case. This is no new news. What they're asking us to do is tell them what our experts might or might not say in return so they can prepare Detective Gish how to respond to that. This is a rebuttal expert witness. We are not required to give notice. Out of an abundance of caution, we gave notice to this honorable court. And we would ask that they're not prejudiced, that they have an expert dealing with digital forensics technologies. We are in the process of working with our experts, what they might or might not discover, what they may or may not find. We don't know in full at this point in time. So we would ask this court, as it relates to Logic Force, that they accept our notice of expert testimony. Again, one of the most drastic remedies, as our courts have pointed out, is to exclude that testimony. And it's pointed out that's a very drastic remedy, is for this court to exclude it. They've known about this expert, an expert in the field of direct digital forensics since 2014. And I think it as indicated in the argument Rule 16, Rule 12, notice requirement is to allow the state time to prepare possible rebuttal proof designed to contradict evidence of the defendant's mental condition. We'll talk about that. Not evidence of a particular defendant's expert identity. It's the content of what the expert testified to. That's not in regards to the rebuttal argument. We feel like that the rule allows it inclusive of itself, and that we give notice. We gave notice should the court feel that we did not comply with the court order in giving that particular notice, then we would ask this court to consider them as a rebuttal witness and allow us to call them as a rebuttal witness. We believe that that would be a drastic remedy for this court to disallow the testimony.
Well, the state has the last word, so.
Your Honor, again, the defense has presented nothing in the law that supports their argument. Their argument is that all defense proof is rebuttal proof, which that necessarily means that their case in chief equates to rebuttal proof. I mean, this is an illogical argument, but more specifically, it is not based in the law. And the law controls these procedures, and it is very specific. And the law specifically says that the court has a responsibility to ensure the fair and just implementation of the rules of criminal procedure. And that it is not fair to have one side be required to follow all of the rules of criminal procedure, and somehow the defense is coming in today and asking this court to not apply a single rule to them. What's even more inherent in their argument is they act as if they have no idea what Detective Gish is going to testify to. However, he has testified in Mr. Vandenberg's first trial. They are very aware of his testimony. They have also had the benefit of having him testify a second time in the co-defendant's trial. It is completely disingenuous for them to come in and say that they have no idea that it just might be rebuttal to Detective Gish. Rule 16 is the rule that applies to this issue, and that rule, as well as Tennessee case law, requires that they provide the state with notice that includes a report. Even more, Your Honor ordered them to provide any reports of expert witnesses by December 1st of 2015. And the defense has not done that. Specifically, as it relates to the digital forensics expert, the state would request that the court consider wherever we are in this, that the defense has a full extraction and a copy of the defendant's entire hard drive from his laptop. The state does not have that information. The state has the data that was provided to the defense. Detective Gish technically has access to it. However, it was not provided as part of the evidence in this case. The state does not have access to it, and the state 1,000% would object to at any point the defense trying to submit any additional information that they gained from that.
You can finish. Okay. Well, as I said, I received the defense response motion this morning, and I haven't had real time to digest it. I understand fully what the state is saying with regard to Rule 16, but I do want to at least review the defense motion as well as the citations in particular, and I will do so, and will let both sides know what I conclude on Tuesday, this coming Tuesday. So you will receive a final order from me this coming Tuesday. All right? Next motion.
Judge, this is actually follow-up and related to the motion to exclude the expert based on Rule 16, but Rule 12.2 as it relates to Dr. Sidney Alexander, who was actually given, again, we consider to be late, untimely notice. But since that comes under Rule 12.2, and without belaboring, re-arguing the law the court already knows, particularly State v. Reed, which is that the court ordered that the expert provide a report. Back on that same December 1st day, we're down here almost 6 months, if not right at 6 months later, 1 month from trial, and we have a name, and that's it. We don't even know if Dr. Alexander has actually even seen Mr. Vandenberg. But Rule 12.2 in State v. Reed, the reason for that rule, the law interpreted by the Tennessee Supreme Court, is so the state would be on notice and have the information available to determine whether or not to seek its own court-ordered evaluation of a defendant, in this case, Mr. Vandenberg. We don't have that. We don't even have, to my knowledge, a curriculum vitae of Dr. Alexander. presents a significant problem, which I submit is one the court can and should cure by disallowing his testimony because of the violation of this court's order and violating State v. Reed and its progeny. And I would, and another court's going to take all likelihood this under advisement, but I would, counsel this morning was mentioned about the drastic remedy of excluding defense proof and citing the all-familiar State v. Brown for right to present a defense as if it trumps everything in the world. Well, it doesn't. Because the laws and the rules are law. And I would submit there is probably, to my knowledge, no better example of that being used by a trial court in making these various determinations in State v. Looper at 118 Southwest 3rd, 366. As the court, for most everyone in the state, has heard of Mr. Looper and his heinous offense, killing Senator Parks. It was well known, well publicized, a very serious matter for both sides. And in that case, the defense was under an obligation to give 12.1 notice of alibi. They came into court, and again, court, there's a beautiful case, I won't try to oversimplify, but basically said, well, these weren't really alibi witnesses, they're something else, call it rebuttal, call it whatever. But the trial court said, yes, they are alibi witnesses, you did not comply with the rules, and it would not be fair to the state while essentially we got a jury here, as they were in that case, and citing, among other cases, Hamilton versus United States versus Hamilton, out of the 6th Circuit, which again obviously is persuasive, not authority only, but it has a very good quote in there about how it places the state in the untenable position of, if this is allowed to happen, Dr. Alexander would come in and say, oh, here's a report that I just did today, or here's a report, or I don't do reports. The state degree takes care of that because an expert cannot avoid that just by saying, oh, I haven't done a report. That's one resort. But in any event, that puts, again, the state in the untenable position of saying, well, back to your paragraph number 7, I know you won't object if we have to ask for a continuance. That's not feasible. That's not fair to the state. It's certainly not fair to the victim in this matter, and who is of the state's utmost concern of having this litigation come to an end, and have it come to an end by a trial of Mr. Vandenberg. That's where we are. I don't mean to reiterate everything that John Norman has said about the reasons, but they co-mingle. They're tied together. Same reasons, different rules, same reasons. It's too late in the proceedings at this point. If counsel were to have a report to provide to the state this morning, we would take a look at it and see what would go from there. But there's not one. I certainly hasn't been one since December 1st. Your Honor's order, I would submit, should mean what said in the court rule. This late date, Dr. Alexander, report or not, is not allowed to testify in the case in chief or rebuttal or whatever they want to call it. Thank you.
All right. Response? Briefly, and not to rehash what is contained in our response, state filed a motion to exclude, we filed a response. I believe our response to the court has suggested it's littered with citations. The state seems to suggest that we cite no authority. There's authority cited throughout our response. For the state to suggest that they are just now learning that Mr. Vandenberg has raised the defense of mental condition and has not given them notice is just absolutely wrong. They got a report from an expert, Stalinsky, in 2014. They've been aware. This court adopted their notice of expert testimony. We adopted their notice of expert. We filed those motions adopting any and all previously filed notices of expert. If they wanted to have Mr. Vandenberg forensically evaluated, they've had all the time in the world to do that. So to come in and suggest to this honorable court that it is us now, today, 2 weeks ago, putting them in the position to ask for a continuance is not true. They have known Mr. Vandenberg's mental condition has been raised and that there has been previous reports Dr. Stalinsky provided to the state referencing Mr. Vandenberg's mental condition on this particular day. Ever since they received that last notice of expert filed in 2014, they could have sought then to get Mr. Vandenberg forensically evaluated, and they failed to do that. The Looper case, what General Moore, what Mr. Moore points out is exactly true. The day of trial with a jury in the back, and the court determined that the notice of alibi, or that it wasn't actually rebuttal. I don't think that the court used the words rebuttal, but I think the court reasoned that it was in fact an alibi defense, and it was the day of trial. They've known now for six weeks prior to trial that we have reassured them of the previous notice of expert testimony as it relates to Mr. Vandenberg's mental health condition. And again, I point out that the rule in 12.2 is not the identity of the presenter of the expert, but in fact what the expert may or may not testify in Rule 12. We believe that this court should allow for multiple reasons. One of the first reasons is simply because we have adopted all previously filed motions, all notices, and have actually requested that this court conduct hearings on motions that haven't been concluded and that require further hearing and proof and testimony. We have adopted those, that they have been on notice since the last notice of expert testimony from Dr. Stalinsky that we plan to raise Mr. Vandenberg's mental condition at the time of this alleged offense. And I would suggest too to the court, we have previously been given a letter from Dr. Furslew in one of their pleadings that has been filed with the court this week. We haven't received a notice of that expert. If they plan on calling Dr. Furslew, we have not received that notice, but they're relying on this particular document. Did they file that notice back in 2014? Probably, and they're going to rely on that. We haven't received notice of that expert. We filed the notice of expert in 2014, and we're relying on that. We're not changing the presentation. They know that the state knows what our defense and what our expert witness may testify to. And as a matter of fact, I would point out to the court as it relates to Dr. Alexander. If Dr. Furslew was to take the stand and say one thing, then we have the opportunity provided by law to rebut that testimony. And we would respectfully suggest that again, I don't want to rehash it. I believe our response will assist the court, and I think it lays out those details and the case law and the authority that it cites. We would respectfully request that this court allow our notices of experts to be, actually I labeled them, I think, amended notices of experts because we have previously given notices of experts.
Final word. Just very briefly, Your Honor, in the cases cited, noticeably talk about whether there's been no prejudice or any bad faith. But with respectfully, counsel say that not complying with the court's order to be considered to be bad faith. We still don't have a report, and it appears as though it would be relying upon a letter. Now, I'm sure Your Honor remembers the business with Ms. Stalinsky, or Dr. Stalinsky, to where it was a letter to Mr. Perez, who had, and we're supposed to have a hearing for her to come in and have hearings about her testimony, which was admissible, and she never came in. So that She was withdrawn. If she was ever tendered, she was withdrawn as a witness by the defense. So to try to piggyback that, I think is again, not, comporting with the rule. We're talking about Rule 12.2. Expert Dr. Alexander, a psychiatrist, a mental health, not Dr. Firsley, who is a psychologist. Mixing apples and oranges here for start talking about him. What we're concerned with is 12.2 state degree and the inadmissibility, and again, no report, as Your Honor ordered to prepare and give to us from their expert. Thank you.
Yeah, and that's what really bothers me, is that there is no report. Again, I will review the defense response, and as I stated a little bit earlier, I'll let you know on Tuesday what I will allow or will not allow. So I think that will resolve that, so you will know by Tuesday. Okay.
Can I just make one comment? I do want to point out to the court that the minute that these experts were retained, the minute that we could retain the services of these experts, this court got notice. These aren't experts that we've held in abeyance for 7 or 8, 9 months. The minute we were able to retain these experts, this court and the state of Tennessee was placed on notice.
Okay. All right, thank you. All right. Any other motions that we were here in court?
Could probably put on the record just a discussion about length of argument.
Length of argument,
Well,
Counsel.
I mean, as I stated to counsel previously, because of the nature of the trial as well as the length of the trial, I'm not limiting counsel to a specific time as I normally do in most of my trials. Particularly, I've never limited any counsel with regard to opening statements. It's primarily to voir dire and closing argument. And as I said in the first trial, I gave both sides leeway with respect to closing argument, and I will do so in this particular trial. So I think that resolves that.
Well, we have just a couple motions the court may wish to consider out here. We have a motion to reveal the agreements of the co-defendants in this case.
Okay, and I think I know what the state's response will be, but
Stands in the testimony from Mr. McKenzie on 2 separate occasions, and that's still the way things are. No agreement with anyone listed that is involved in this case.
Just briefly, since it is the defense motion on to reveal the agreements, it's just not as simple. The case law of Giglio and Bolden points out it's just not as simple as saying we don't have a written agreement or saying that there is no agreement. What is important is if a co-defendant believes or his lawyer believes that there is some type of consideration given for participation in trial, participation in the prosecution. We do know, for example, there is an audio recording where defendant Banks is talking about an immunity agreement. And they suggest through the state of Tennessee that they have that document. We've not seen that document. It is there. They talk about it. We've not seen this immunity agreement with the bank. So if the state, we can't tell them, ask them to do something that's untrue, but the record needs to be clear that the state has not had any conversations with any of the defense lawyers, any of the defendants, or any of the witnesses, which would lead them to believe that there is some consideration for their participation as a witness or some participation in this case at trial pursuant to Bolden and Giglio. We're entitled to that information to properly cross-examine any of the witnesses that would be presented at trial. But we would suggest to the court that there, in our discovery that we have received, there is the conversation regarding an immunity agreement, and that the immunity agreement exists, and it's with co-defendant Banks in this particular case. Yes, we've not seen that immunity agreement.
This is at least the second, if not the third time that this has been before the court, and it remains the same. testimony is in the record, both Mr. McKenzie and the other two individuals, their cases have been disposed of, as well as suspect Mr. Boyd, whenever he was not going to be a witness in this matter. Mr. Banks is a co-defendant, a witness. So, on behalf of the state, they have the information that they are entitled to. There's nothing else out there.
All right. And I think, well, almost goes without saying, anytime a co-defendant testifies at trial, he or she expects consideration, whether there has been any discussion with regard to that. And usually, in my experience, there usually is no discussion with regard to giving consideration. They are doing it, the witness is doing it with the expectation of receiving consideration.
Governor, do I take that comment to mean that there is no immunity agreement with co-defendant Banks?
I don't know about any immunity agreement.
But it's
I
referenced
haven't
in,
seen- I don't believe.
Well, we haven't seen one. We'd like to see one. It's referenced in the interviews with, I think General Thurman was there. And we're entitled to that agreement, if there is in fact an agreement.
Judge, as far as I know, and if Thurman's not here, but to our knowledge, we've provided everything. I believe Mr. Banks is represented by Mark Scruggs. Soon be rightfully, wrongfully may speak with counsel, but to the best of my knowledge, the standard today, they have all paperwork, and obviously from the transcript, they have that, so there's nothing hidden.
All right. Well, okay. What's next?
Judge, we had previously filed a motion for transcripts, and I know we spoke about this briefly, and I don't think that our motion was well communicated when we spoke about it orally. The motions for transcripts, the motions that we filed for transcripts relate to pretrial hearings and pretrial motions and orders. We have obtained a copy of the court file maintained by the Davidson County Clerk's Office. And just as it relates to Mr. Vandenberg, there have been, there may be some waiver as to these, not by many, but there's been a total of 26 motions filed by prior counsel. There's only 8 orders, 8 rulings from this court that is contained in that file, whether they be written or something. We're asking for the transcripts of those hearings on motions, and I think my motion, or our motion, would indicate that some of those may have occurred during trial. We've only got some of those may have occurred, majority of them occurred pre-trial. My understanding is some of those motions may have just been granted or dispelled orally, but we need transcripts of those motions and not transcripts of the motions, transcripts of the motions hearings and any other orders. I don't mind to work with Ms. Halstead, but that is what the data that we see is that there's been 26 motions filed. We've only got eight written orders. I'm not saying that the court has not ruled on those other motions, but we surely need to know. We can't wait that. Can't wait for appeals purposes. We need to litigate and hear those motions that have not yet been heard, and the only way to conclude that is for us to have transcripts of the actual motions that were heard. Some of them were heard on the same day. There may have been 2 or 3 motions, and that's even including those. So we would like for this court to order that the transcripts as it relates to Mr. Vandenberg's motion, pre-trial, during trial, that we be provided so we know exactly what has been. We know what's been raised by the file, but we do not know what this court has considered. And we surely can't run the risk of waiving that for Mr. Vandenberg. And also, we need to know how the court instructed and ruled, and more importantly, the testimony that was offered during those motions hearings. We're just asking the court to get this transcript.
Well, I mean, have you communicated with the court reporters?
We did, and I thought out of an abundance to try to save time, is that we asked just for the audio recordings because we knew it would take some time to probably find those and then transcribe. I mean, she suggested she couldn't get this audio recordings because there's private conversations that go on, and we understand that. We'll communicate with her to get them, but it was my understanding from those email communications that she's going to have to know exactly what days we can provide those to her, but absent an order from the court, we need to, I think she would need to actually get them completed expeditiously.
Well, I'm sure she's working on it. I mean, I can communicate with her with regard to those, but it's my understanding that she is working on transcripts.
And I think she's working on the transcript, maybe the last trial. I don't know that she's working on, I don't know, but I don't mind to provide an Excel spreadsheet with the motions that we have discovered in the file that has been filed, and there's not orders on, and maybe we can identify them that way. But we can't run the risk of not litigating an issue that's been previously raised. And they may have all in fact been orders and heard, but we need to know that.
And my recollection is that there were a number of rulings that were made on the record without necessarily submitting a written order.
That's true, but we just don't have that record transcript as to what. And Mr. Moore makes a comment today that there was a notice of expert that was withdrawn. We're not aware of that, so those things raises concerns for us.
Well, I just respond to that, is that Ms. Stilinski didn't show up or didn't appear, so there's probably no written, she's not coming, but that's withdrawing. But I would like, just for the record, this proceeding, that the court would know that Mr. Perez was here throughout all of those proceedings. So he is the continuity.
All right. What else do we have?
I think the remainder are made by law.
Right. Yeah, I'll have to give those a chance. I'll hear those in a little while. I need to take about a 10-minute break, come back and deal with some of the matters I have on the docket, and then I will come back to the lawyers in the Vanderbilt matter. All right?
All rise. Court will be in a brief recess. Hey, James. Yes, sir. Let me in.
Do you want your mic? You want
So, you might as well just, we'll let them until we get this result. I mean, just.
That's a dollar.